Welcome everyone to the On the Docket podcast. This is the third episode, and this one is going to be full of firsts. This is the first episode dealing with the 14th Amendment, the first episode dealing with the Equal Protection Clause of the 14th Amendment, the first case taking place in the 1950s, and the first case where a unanimous opinion was delivered. For the previous two episodes, we've dealt with some very recent cases, one from 2019 and another from 2007. Today, however, we're going to go way back in our time machine to 1954. Join me as I analyze the landmark Supreme Court case, Hernandez v. Texas. Pete Hernandez was a 21-year-old Mexican-American cotton picker living in Edna, a small town in Jackson County, Texas. One night, Pete Hernandez was down at the local bar drinking with the other cotton pickers when Joe Espinoza entered the bar. Joe Espinoza was a tenant farmer, meaning he was renting the farmland from somebody else. Espinoza had employees that picked the cotton on the farm. Most of those employees were down at the bar this very night, including Pete Hernandez. Espinoza just wanted to talk with his employees, but he ended up getting into an argument with Hernandez. Espinoza then mocked Hernandez for having a handicapped leg. Espinoza reportedly asked Hernandez what woman would want a man like him. Infuriated, Pete Hernandez left the bar and went home. He retrieved a gun from his house and returned to the bar, where he fatally shot Espinoza. The shooting occurred in front of numerous witnesses, so it didn't take long for the police to arrest Hernandez. Before the trial began, Pete's lawyers tried to get the indictment and the jury thrown out. His lawyers argued that Mexicans had been purposefully excluded from serving as jury commissioners, grand jurors, or petite jurors, even though there were Mexicans living in Jackson County, Texas, who were qualified to perform this task. For those of you who don't know, jury commissioners are responsible for choosing the panel of people to serve as potential jurors for a particular case. The grand jury typically consists of 23 people, and they help determine whether or not a prosecutor should bring charges against a defendant, and a petite jury hands down verdicts of guilt or innocence. So Pete Hernandez's lawyers are essentially saying Mexicans have been purposely barred from serving in those three positions, even though there are people in Jackson County who are qualified to serve in those positions. Hernandez's lawyers even crunched the numbers to show that 11% of the population of Jackson County had a Mexican or Latin American surname and was over the age of 21, yet, quote, for the last 25 years there is no record of any person with a Mexican or Latin American surname having served on a jury commission, grand jury, or petite jury in Jackson County, unquote. Hernandez's lawyers argued that because Pete Hernandez himself was Mexican American and Mexican and Latin Americans were being excluded from serving on juries, that he was deprived of his 14th Amendment right. They argued that the Equal Protection Clause had been violated because members of his own class were being barred from the jury that would hear his case. The Equal Protection Clause of the 14th Amendment says that no state shall deny to any person within its jurisdiction the equal protection of the laws. So in other words, Hernandez's lawyers are making the case that because white jurors oversee cases in which white people are on trial but Mexican and Latin American people are barred from serving on any juries, that Pete Hernandez, who is Mexican American, is not being given equal legal protections by Jackson County and the state of Texas at large. Now, this next statement may not seem intuitive, but this was a big deal at the time and a very bold statement to make. The population of Mexican and Latin Americans living in the southern United States at this time was numbering in the millions, and even though these states claimed that whites and Mexicans/Latin Americans were treated the same, the Mexican and Latin Americans living there knew this to be untrue. They felt like they were being treated as a special class of citizens, even though under the law they were meant to be seen as equal to white people. This was one of the first times that notion was being challenged in a legal setting. Unfortunately, the legal challenge got off to a rocky start. The trial court judge denied the motion to remove the indictment and the jury. When the case went to trial, Hernandez's lawyers repeated the motion, which was again denied. During the trial, Hernandez's team was only allowed to call Hernandez to the witness stand, whereas the state got to call 8 witnesses to testify against Hernandez. In October of 1951, an all-white jury found Hernandez guilty of murder after 4 hours of deliberation. They sentenced him to life in prison. Hernandez appealed the decision to the Texas Court of Criminal Appeals on the grounds that the trial should be declared a mistrial because of the all-white jury and the denial of motions by the judge. The appellate court upheld the trial court's verdict but declined to answer whether or not Hernandez's 14th Amendment rights had been violated. The appellate court upheld his conviction on the basis that Mexican and Latin Americans fall under the racial category of white as opposed to African American, because in the legal system at that time, that was all they had. They had white and African American. and that since no other Mexican American had challenged their classification as white, an all-white jury did count as equal protection under the law. Hernandez's team then appealed to the Supreme Court, who agreed to hear the case. Now, another thing to bear in mind during this whole thing is that the Supreme Court is based in Washington, D.C., so all of the justices live somewhere in the United States. 2 of the justices had been born in the South, so only 2 had an idea of what was going on down there. This meant that the justices were pretty oblivious to the discrimination and the mistreatment that was happening to Mexican and Latin Americans in the South. In fact, most people from the North were oblivious to this and had no idea that there was such a prevalent problem of discrimination against Mexican and Latin Americans. That meant that Hernandez's lawyers would be fighting an uphill battle in the Supreme Court. Speaking of the Supreme Court, I want to quickly delve into the justices that would be hearing this case. This case was decided by the Warren Court, meaning that Earl Warren was the Chief Justice. Warren was appointed by President Eisenhower to serve as the Chief Justice following the death of Chief Justice Fred Vinson. Eisenhower made this move in October of 1953 when the Senate was in recess, and it wasn't until 1954 that he was confirmed by an in-session Senate. Warren strongly believed that the role of the court was to enact justice, which sometimes opposed another faction of justices that emphasized the importance of judicial restraint. This opposing faction of judges felt that it was more important to give the right of way to the policies made by Congress and the President. Earl Warren was also seen as a moderate, holding some conservative values and some liberal values. Next up is Associate Justice Hugo Black. Justice Black was and still is a controversial figure in politics in the world of law, mainly due to his membership in the KKK. According to Black, though, he left the Klan before ever getting into politics and continued to denounce it throughout his political career. Franklin Delano Roosevelt was the one to nominate Hugo, and he did this because as a senator, Black voted in favor of all of the New Deal policies, which FDR wanted. According to FDR, he wanted a very religious, quote, New Dealer, unquote, to be on the court. If confirmed by the Senate, Black would be replacing the retiring Willis Van Devanter. At the time of Hugo Black's nomination, he was serving as a senator. It was tradition for a senator being nominated to the Supreme Court to be confirmed immediately and with no debate. However, with the nomination of Hugo Black, the Senate decided not to follow through with this tradition. Instead, his nomination was referred to the Senate Judiciary Committee, and ultimately they approved of him by a vote of 13-4. On August 17, 1937, the Senate considered this nomination and, following 6 hours of debate, confirmed him to the Supreme Court by a vote of 63-16. Despite concerns of his deep Southern roots and his Klan membership, Justice Black would become known for his support of civil rights and civil liberties. In addition to Hugo Black, we also have Justice Stanley Reed. Reed was another FDR-nominated justice and was actually considered to replace Willis Van Devanter before Hugo Black was nominated. Going into Reed's confirmation hearing, many people were afraid that it would be a long and bitter battle with plenty of fiery debate, because that was what happened during the confirmation of Hugo Black. However, the Senate confirmed Reed with relatively little commotion, and he was confirmed to the court in January of 1938. Reed was similar to Earl Warren in that he had both conservative and liberal opinions. On issues regarding civil liberties, economic regulation, and civil rights, Reed tended to be more liberal. However, on issues regarding free speech and national security, Reed was known to lean more conservatively. Next up is Justice Felix Frankfurter. Frankfurter was another FDR-nominated judge, and he was meant to replace Justice Benjamin Cardozo, who had passed away. The confirmation of Frankfurter is notorious for the opposition that arose to attempt to block his confirmation. People were not happy with Felix for several reasons, one of which was that Felix was considered to be an unofficial advisor to the president. People were also concerned about his affiliation with special interest groups like the ACLU. On top of all this, though, Frankfurter was born in Austria-Hungary, and people thought that he was a foreign-born anti-Christian invader who was also a part of the larger communist movement in America. However, despite these controversies, Felix was appointed to the higher court and began his justiceship in 1939. Frankfurter was a strong advocate of judicial restraint and was known for refusing to apply the federal constitution to the states, which is known as selective incorporation. We also have Justice William Douglas. In 1939, following the retirement of Justice Louis Brandeis, FDR nominated Douglas to take his spot. Brandeis himself also said that he wanted Douglas to replace him when he retired. He was confirmed on April 4th by a vote of 62-4. In the court, Justice Douglas often found himself in opposition to Justice Frankfurter over the idea of judicial restraint. While Frankfurter was a staunch supporter of judicial restraint, Douglas did not care for it. He was known by his colleagues as being bored, rude, ungrateful, and abusive to his law clerks. He was so abusive to his law clerks that they called him a shithead behind his back. Judicially, Douglas didn't often justify his opinions with prior text or precedent. He hastily wrote his opinions and often published a first draft. In addition to Douglas, Justice Robert Jackson was serving on the court during this case. In 1941, Chief Justice Charles Hughes retired, creating a vacancy in the Chief Justice spot. Associate Justice Harlan Stone was confirmed to replace him, but that meant that there would now be a vacancy in the Associate Justice spot that Harlan Stone used to hold. This spot was filled when FDR nominated Robert Jackson. Jackson was confirmed in July of 1941. In the court, Jackson had many personal and professional disagreements with Justice Hugo Black, but honestly, it's a long story for another time. Moving on from Justice Jackson, we have Justice Harold Burton. Justice Harold Burton was a replacement for the retiring Justice Owen Roberts. The president at the time was the Democrat Harry Truman, and Truman wanted to make a gesture of bipartisanship, so he nominated Burton since Burton was a Republican. Burton was nominated on September 19th, and less than 24 hours later was confirmed to the High Court by a unanimous vote in the Senate. On the court, Burton acted as a centrist, but strayed somewhat into the conservative bloc of judges in a few cases. After that is Justice Tom Clark. Tom Clark was another Truman-nominated judge, and he was meant to replace Justice Frank Murphy, who had passed away. There was a lot of controversy surrounding Clark's nomination since he was seen as a personal friend and informal advisor to President Truman. Nonetheless, he was confirmed to the Senate in 1945 with just 8 dissenting votes. Justice Tom Clark tended to vote with Justice Fred Vinson, but in 1953, Vinson died of a heart attack. Earl Warren took his place, and after that, Clark produced an array of opinions that were both conservative and liberal. Regarding civil rights, Clark favored giving deference to governmental laws that promoted racial equality. When the court heard Hernandez v. Texas, Clark was just one of 2 justices who hailed from the South, which gave him some additional impact in persuading the justices from one side or another. Last but not least, we have Justice Sherman Minton. In 1945, President Truman nominated Minton to replace the deceased Justice Wiley Rutledge. Minton's nomination received some mixed reviews. Those who supported him pointed to his extensive experience as a judge in the circuit courts as well as his education background. However, those who didn't like Minton pointed to the fact that he was a friend of Truman's, that he supported the court-packing plan when he was a senator, and his less-than-ideal health. Minton's opponents executed numerous tactics to delay his confirmation hearing, but on October 4, 1949, he was confirmed by a vote of 48 to 16. On the court, Minton loved to uphold the original content of a piece of legislation. That being said, Minton also held great contempt for racial segregation. Regarding civil liberties, however, Minton strongly believed in a concept known as fundamental fairness. Fundamental fairness is the idea that certain rights can be regulated or even restricted so as not to violate the rights of others. So, now that we've introduced the judges, let's just quickly remind ourselves of the constitutional question being asked here. Essentially, the question the judges have to answer here is it a denial of the 14th Amendment Equal Protection Clause to try a defendant of a particular race or ethnicity before a jury where all persons of his race or ancestry have, because of that race or ethnicity, been excluded by the state? And normally when I do these, after I read the constitutional question, I highlight some excerpts from the oral arguments. I can't do that with this case though because the transcript of the oral arguments aren't available. I don't know why, but I think they just got lost because the case is pretty old. So instead of doing the oral arguments, I'll just skip straight to the unanimous opinion delivered by Chief Justice Earl Warren. Also, be forewarned that Earl Warren uses some racially charged language in this opinion that I'm not comfortable saying, so I will be substituting those terms with less racially abrasive terms. The petitioner Pete Hernandez was indicted for the murder of one Joe Espinoza by a grand jury in Jackson County, Texas. He was convicted and sentenced to life imprisonment. The Texas Court of Criminal Appeals affirmed the judgment of the trial court. Prior to the trial, the petitioner, by his counsel, offered timely motions to quash the indictment and the jury panel. He alleged that the persons of Mexican descent were systematically excluded from service as jury commissioners, grand jurors, and petit jurors, although there were such persons fully qualified to serve residing in Jackson County. The petitioner asserted that exclusion of this class deprived him, as a member of the class, of the equal protection of the laws granted by the 14th Amendment of the Constitution. After a hearing, the trial court denied the motions. At the trial, the motions were renewed, further evidence taken, and the motions again denied. An allegation that the trial court erred in denying the motions was the sole basis of petitioner's appeal. In affirming the judgment of the trial court, the Texas Court of Criminal Appeals considered and passed upon the substantial federal question raised by the petitioner. We granted a writ of certiorari to review that decision. In numerous decisions, this court has held that it is a denial of the equal protection of the laws to try a defendant of a particular race or color under an indictment issued by a grand jury or before a petit jury from which all persons of his race or color have, solely because of that race or color, been excluded by the state, whether acting through its legislature, its courts, or its executive or administrative officers. Although the court has had little occasion to rule on this question directly, it has been recognized since Strouder v. State of West Virginia that the exclusion of a class of persons from a jury service on grounds other than race or color may also deprive a defendant who is a member of that class of the constitutional guarantee of equal protection of the laws. The state of Texas would have us hold that there are only two classes, white and black, within the contemplation of the 14th Amendment. The decisions of this court do not support that view, and except where the question presented involves the exclusion of persons of Mexican descent from juries, Texas courts have taken a broader view of the scope of the Equal Protection Clause. Throughout our history, differences in race and color have defined easily identifiable groups which have at times required the aid of the courts in securing equal treatment under the laws. But community prejudices are not static, and from time to time other differences from the community norm may define other groups which need the same protection. Whether such a group exists within a community is a question of fact. When the existence of a distinct class is demonstrated, and it is further shown that the laws, as written or as applied, single out that class for different treatment not based on some reasonable classification, the guarantees of the Constitution have been violated. The 14th Amendment is not directed solely against discrimination due to a two-class theory, that is, based upon differences between white and black. As the petitioner acknowledges, the Texas system of selecting grand and petit jurors by the use of jury commissions is fair on its face and capable of being utilized without discrimination. But as this court has held, the system is susceptible to abuse and can be employed in a discriminatory manner. The exclusion of otherwise eligible persons from jury service solely because of their ancestral or national origin is discrimination prohibited by the 14th Amendment. The Texas statute makes no such discrimination, but the petitioner alleges that those administering the law do. The petitioner's initial burden in substantiating his charge of group discrimination was to prove that persons of Mexican descent constitute a separate class in Jackson County, distinct from whites. One method by which this may be demonstrated is by showing the attitude of the community. Here, the testimony of responsible officials and citizens contained the admission that residents of the community distinguish between white and Mexican. The participation of persons of Mexican descent in business and community groups was shown to be slight. Until very recent times, children of Mexican descent were required to attend a segregated school for the first 4 grades. At least one restaurant in town prominently displayed a sign announcing "No Mexican served." On the courthouse grounds at the time of the hearing, there were 2 men's toilets, one unmarked and the other marked "Colored Men" and "Hombres aquí," which means men here. No substantial evidence was offered to rebut the logical inference to be drawn from these facts, and it must be concluded the petitioner succeeded in his proof. Having established the existence of a class, petitioner was then charged with the burden of proving discrimination. To do so, he relied on the pattern of proof established by Norris v. State of Alabama. In that case, proof that blacks constituted a substantial segment of the population of the jurisdiction, that some blacks were qualified to serve as jurors, and that none had been called for jury service over an extended period of time, was held to constitute prima facie proof of the systematic exclusion of blacks from jury service. This holding, sometimes called the rule of exclusion, has been applied in other cases, and it is available in supplying proof of discrimination against any delineated class. The petitioner establishes that 14% of the population of Jackson County were persons with Mexican or Latin American surnames, and that 11% of the males over 21 bore such names. The county tax assessor testified that 6 or 7% of the freeholders on the tax rolls of the county were persons of Mexican descent. The state of Texas stipulated that, quote, "For the last 25 years there is no record of any person with a Mexican or Latin American name having served on a jury commission, grand jury, or petit jury in Jackson County," unquote. The parties also stipulated that, quote, "There are some male persons of Mexican or Latin American descent in Jackson County who, by virtue of being citizens, freeholders, and having all other legal prerequisites to jury service, are eligible to serve as jury members or of a jury commission, grand jury, and or petit jury, unquote. The petitioner met the burden of proof imposed in Norris v. Alabama. To rebut the strong prima facie case of the denial of the equal protection of the laws guaranteed by the Constitution thus established, the state offered the testimony of 5 jury commissioners that they had not discriminated against persons of Mexican or Latin American descent in selecting jurors. They stated that their only objective had been to select those whom they thought were best qualified. Their testimony is not enough to overcome the petitioner's case. As the court said in Norris v. Alabama, quote, that showing as to the long-continued exclusion of blacks from jury service, and as to the many blacks qualified for that service, could not be met by mere generalities. If, in the presence of such testimony as defendant adduced, the mere general assertions by officials of their performance of duty were to be accepted as an adequate justification for the complete exclusion of blacks from jury service, the constitutional provision would be but a vain and illusory requirement. The same reasoning is applicable to these facts. Circumstances or chance may well dictate that no persons in a certain class will serve on a particular jury or during some particular period, but it taxes our credulity to say that mere chance resulted in there being no members of this class among the over 6,000 jurors called in the past 25 years. The result bespeaks discrimination, whether or not it was a conscious decision on the part of any individual jury commissioner. The judgment of the conviction must be reversed. To say that this decision revives the rejected contention that the 14th Amendment requires proportional representation of all the component ethnic groups of the community on every jury ignores the facts. The petitioner did not seek proportional representation, nor did he claim a right to have persons of Mexican descent sit on the particular juries which he faced. His only claim is the right to be indicted and tried by juries from which all members of his class are not systematically excluded. Juries selected from among all qualified persons regardless of national origin or descent. To this much he is entitled by the Constitution. Reversed. So that was the unanimous opinion written by Chief Justice Earl Warren, and I think there's a lot of good stuff to unpack there. Warren basically says that going into this case, Hernandez and his team had to prove a number of things in order to prove discriminatory practices with regards to jury selection. The first thing Hernandez had to prove was that Mexican Americans were indeed considered a separate race from white. Warren says that Hernandez proved this by providing evidence of segregated bathrooms, restaurants that refused to serve Mexicans, and testimony from numerous residents of Jackson County which confirmed this idea. The next thing that Hernandez needed to prove was that there were Mexican Americans living in Jackson County that were qualified to serve on a jury. This was proved with the statistics that Warren mentions in the 7th paragraph. With these 2 claims proved, Warren goes on to say that it is only right for this decision to be reversed, and it was. So, what happened to Pete Hernandez? As ordered by the Supreme Court, he was given a new trial. This time, Mexican Americans were on the jury. Unfortunately, Hernandez was still found guilty. Sometimes the ending isn't always what you expect. Speaking of endings, that is the end of this episode of the On the Docket podcast. I will see you in the next episode.